Welcome back to another video, this time about the FAIS Code of Conduct. Now, the FAIS Code of Conduct is probably the biggest or the most overwhelming part of your studies, and for a very valid reason. It's kind of all over the place. There's no specific theme or energy to the Code of Conduct. It touches on anything and everything in the financial services environment. We start off with the specific duties, and then from there we go into disclosures. After disclosures, we go to rules of advice, custody of financial products and funds, advertising, complaints. It's just all over the place. That's why my recommendation is when you approach the code of conduct, divide it into smaller sections, just to allow your brain to have some time to adapt to the change in language, the change in theme, the change of the general ideas. So, with our code of conduct, we always start with the general duty. It says in the Act that it's the general duty of all FSPs to render financial services honestly, fairly, with due skill, care, and diligence in the interests of clients and the integrity of the financial services industry. In the exam, if they ask you about the general duty, they tend to change this word. So make sure that you familiarize yourself with this sentence, with this paragraph. It feels like it's not very important. We can very easily neglect the general duty, but it is important for you to know the sentence. How do we get to the general duty? By complying with the specific duties. It says in the FAIS Code of Conduct that all representations made and all information provided to a client must be factually correct. It must be provided in plain language to avoid any uncertainty or confusion, and it must not be misleading. It must be adequate and appropriate, which means that whatever representation or information we provide the client with must be appropriate for the client's needs. The clients must be able to benefit from what we are telling them. Then it says it must be provided timeously to give the client sufficient time to make an informed decision. This means that we are not allowed to bully the client into making an immediate decision. If the client needs time to think about it, we need to allow that time. It also says that all of our representations made and information provided may be provided orally, but must be reduced to writing within 30 days. All communication, all verbal communication with the client must be reduced to writing within 30 days. In the exam, they're going to try and trick you. They're going to try and convince you that this is not needed. It is always needed. If they give you a scenario, and they normally go into a scenario, or they use a scenario similar to this one, where they would tell you that a representative disclosed the conflict of interest management policy to a client verbally. They asked the client, do you understand the conflict of interest management policy? The client said yes. They said, do you have any questions on our conflict of interest management policy? The client said no. And then they ask you, is it still necessary for this representative to send the client the conflict of interest management policy in writing? And the answer will always be yes. They're going to try and convince you that it's not by telling you the client agreed to that. The client said he had no further questions. He understands fully. We still have to reduce it to writing within 30 days. Writing must be in clear and readable print size, spacing, and format. No funny business, no fine print. It must include all amounts, sums, charges, values, remuneration, commissions, anything with a rand value must be disclosed to the client. And then it says this needs not to be repeated, which means that if my client did ask for time to go and think about it, and they come back saying that they're now ready to take up the policy, we don't have to go through everything again. Legally, we don't have to. Remember, your organization you might have your own internal rules there, but legally, it's not a requirement unless we've had policy wording changes that will affect the client, or unless the client specifically asks you to repeat what you have said previously. The specific duties then touches on conflict of interest. Now, the main thing with conflict of interest is we need to understand that conflict of interest is not illegal. It must just be managed very, very carefully. So every FSP must have a conflict of interest management policy. This is their internal policy where they disclose to clients what conflict of interest exists, what measures were taken to try and avoid the conflict of interest. We also need to disclose to the client any ownership or financial interest that the FSP or the representative may become eligible for. So even if we're not guaranteed that we'll get that incentive or financial arrangement, it's just the possibility is there that needs to be disclosed. We also need to, in the conflict of interest management policy, disclose the nature of any relationship or arrangement with a third party that could give rise to conflict of interest. The FSP must still try to mitigate or limit conflict of interest as far as possible, and then we have to give our clients access to the conflict of interest management policy. After that, our code of conduct touches on record keeping. Now, with record keeping, we need to keep in mind that we have two different sides to record keeping. We have transaction record keeping and we have compliance record keeping. Now we're going to focus on transaction record keeping for this part. Transaction record keeping is when we need to keep record of transactions. Now we're all aware of the 5-year rule. I think in the industry overall, everyone knows about the 5-year rule. It says that records must be kept for a period of 5 years after the termination of the product transaction or the business relationship. After the termination is an extremely important part to this sentence. What they'll do in the exam is they'll try and trick you. They're going to say after the rendering, or they're going to say before the termination, or before the rendering, before the rendering. All of these incorrect. It's after the termination. Because think about it this way. After termination, basically termination just means it's cancelled or the product is no longer active or whatever. If my client bought a policy in 2010 and they kept it active and they now want to claim in 2020, 10 years later, I must have their information on record. I must have record of their policy. That's why we only start record keeping after determination. So if my client cancelled the policy in 2020, that's when the 5-year record keeping period starts. Because imagine it started in 2010 when I sold the policy. Now, if I only had to keep record for 5 years after I sold the policy, it means I would have kept record until 2015. In 2020, client comes and he has a claim, and we say, oops, client, we can't help you with your claim because we don't have any record of you, because legally we're only required to keep it until 2015. That's why it can't be after the rendering. It has to be after the termination or cancellation, which means if this client that took out a policy in 2010 cancels their policy in 2021, the 5 years will only start at that point of cancellation. Right. What must the FSP keep record of? They need to keep record of verbal and written communication. They need to be able to store and retrieve those records, and client records must be kept safe from destruction. Records should be available for inspection within 7 days after the authority's request, and this is 7 normal days, not 7 business days. And then records are allowed to be kept electronically or physically. It does not matter as long as these requirements are met. As long as we can keep record of written and verbal communication, it's retrievable, and client records are safe from destruction. Right, next part of the code of conduct is probably the biggest headache. So we need to dissect it and get an easier way to understand it. The disclosures. We've got different disclosure requirements for product suppliers, providers, and then for the actual product or service. The easiest way to study this part is to use examples in your organization. If we're going to think of product suppliers, we think of whose product am I selling? Yes, I work for 123 Auto Dealers, but I sell products from the Innovation Group. Yes, I work for Santam, but I sell products from Guard Risk. Okay, things like that. So yes, I work for King Price, but I sell products from GRSA. So here we think of who supplies us with the product. We're going to use the King Price example. So I work for King Price and my product supplier is GRSA. My product supplier for things like tire and rim cover, dent and scratch warranties, mechanical warranties, so those kind of products. So in this scenario, King Price is the provider selling the policy, and GRSA is the product supplier. Okay, so what do we need to disclose about GRSA, our product supplier? Basic contact details, so name, physical location, postal and telephonic contact details. Then we need to disclose the contractual relationship between the product supplier and the FSP. We don't have to give details about the contract, just the fact that there's an agreement in place and our FSP is allowed to sell the products of this product supplier. Then for our product supplier, we need to disclose the names and contact details of the relevant compliance and complaints departments, both. You'll see that when we get to the provider, the FSP, we only need to do one of these two. So important one, an easy trick. We also need to disclose any condition or restriction that was imposed on the product, on the FSP by the product supplier. So example of that is when a product supplier says, um, to sell their products, the rep must have at least 1 year's experience. Okay, that's not a legal condition or restriction. That is a conditional restriction that the product supplier has imposed on the provider. Now, important for exam purposes will be these two here, NB, NB. They love asking about this because they know it's not general knowledge and you will not know it if you did not study. So it says if the FSB holds more than 10% of the product supplier's shares, that must be disclosed. So example, if King Price owns more than 10% of GRSA, that needs to be disclosed. And it's important to note that it's more than 10%, not 10% exactly, more than 10%. The same with the last block here. It says the fact that the FSP received more than 30% of its total remuneration from the product supplier in the last 12 months. So if King Price received more than 30% of its total remuneration over the last 12 months from GRSA, that needs to be disclosed. In the case of these last two blocks, if it's not the case, if King Price does not own more than 10% of GRSA and they did not get more than 30% of their total remuneration over the last 12 months from GRSA, then they don't have to disclose anything. This is only when applicable. Disclosures about the provider. So this is then the FSP selling the product. In our case, if we go and we continue with the same example, this is going to be King Price. So here, basic contact details are not enough. We need to disclose full business and trade names, registration number, postal and physical address, telephone and cellular phone details, web and email address. So all of our contact details. The client needs to know exactly how to get hold of us. Then details about the legal and contractual status of the provider. This is normally where the FSB would say we are an authorized FSB and a registered entity under the Companies Act. Names and contact details of the relevant compliance department only. So here we don't have the complaints department as a requirement. Reason for that is we need to have our complaints policy as a separate disclosure. Details of the FSB license. So we already mentioned we have a license. Now we're mentioning what category, which product categories, which classes of business. We then have to disclose about King Price. We need to disclose that we do have professional indemnity cover or fidelity insurance cover. We don't have to give details of where we are insured, for what amount, nothing like that. Just the fact that we do have those types of insurance in place. Then we need to disclose whether the representative is working under supervision or not. And any exemptions that our FSP was granted by the commissioner must be disclosed. Example, if there's a FAIS rule that says we need to have 10 blue balloons in the reception area at all times, then, and we've been exempted from that rule, then we need to inform clients that we don't need 10 red balloons or 10 blue balloons. We have been exempted from that specific requirement. Right. Disclosures about our actual financial service or product. So this is what we are selling to the client. In our case, we're going to think about the tire and rim warranty that we mentioned before, maybe the mechanical warranty that we mentioned before. So it says the provider, the FSB, must provide a reasonable and appropriate general explanation of the nature and material terms of the contract or transaction. Then provide full information on the name, class, and type of financial product and the full nature and extent of benefits. Now, normally we do this in writing. Ooh, in writing. There we go. And this part we normally discuss verbally, but it's not a must. We can do both in writing, both verbally, as long as we also then, if we do discuss it verbally, reduce it to writing within 30 days. Now, if our product is specifically marketed as an investment product or it has an investment component to it, we have additional disclosures. So when we have an investment product, we also have to disclose how the value of the investment is determined. We need to have separate disclosures for any fees or charges that will be levied against the product. So that will basically be subtracted from our investment amount. We also need to disclose information about past performance when the client requests it. And when we see the term past performance, we immediately know past performance is not guaranteed. We cannot promise clients that what happened in the past will continuously happen in the future. So we always have to have a warning statement accompanied with past performance saying that warning, past performance is not guaranteed, or warning, past performance is not indicative of future performance. And then our rebate and platform fee arrangements must also be disclosed. This is if we have any other additional arrangement with our product supplier where we might get more money than we initially told the client. Done with our disclosures into furnishing advice. What are the rules? Now, the rules say that we can't just give advice to the client randomly. It needs to be based off of something. And just a quick reminder, advice means to sell. So advice is a sale or a selling or whatever you want. As long as you see the dollar sign, I'm happy. Now it says before we can give the client any kind of advice, aka before we can sell the client any financial product, we have to get sufficient information from the client to determine their needs and objectives. We need to ask questions. We need to get information. We need to understand what their goals are, what their financial goals are, what are they trying to achieve by asking us to help them decide on a financial product. Then we take the information that we've received from the client and we conduct a needs analysis. So we basically take the information and we compare it to what we can offer the client. After we have done the needs analysis, we identify the most appropriate financial product, and that is what we will then ultimately advise the client on. When replacing a product, so the client has this product and we are replacing it with a different version of the same product, it says that in addition to doing a needs analysis, we also need to disclose all implications, costs, and consequences of the replacement. And then the FSP must take reasonable steps to ensure that the client understands the advice. So it is expected of the FSP to make sure that the client understands the advice. In terms of our needs analysis, $1 million exam question is when they try and trick you with the needs analysis. Now remember, if we're doing a needs analysis, it is for the purpose of giving advice, right? So when do we give advice? Only if we represent a category 1 FSP. That's the only one that sells. What do we know about a category 1 FSP? We act on client instruction. So in terms of the needs analysis, if the client refuses to do a full needs analysis, refuses to give certain type of information, or has to leave in the middle of conducting the needs analysis and then tells you to just select whatever you think is best based on the limited information, you are acting on client instructions. So those are things that you are allowed to take into account and include, or it basically allows you to conclude the sale. Right, so if a client says, no, I don't want you to do a full needs analysis, I want you to focus on this specifically. Or I can't give you enough information now, I'm in a hurry, but use the limited information to make a decision on my behalf. Or if the client says, I'm not going to give you any information, I just want you to sell me this product. Obviously, internally, we know that would be very difficult, but legally it's allowed because we are acting on client instruction. Right. What do we do when the client does not follow the advice? We're not allowed to bully them. We are not allowed to beg them. We are not allowed to emotionally manipulate them into making a decision. It just says that if a client does not follow the advice, aka they're not selling what we're offering them, we just need to make sure that they understand that there's obviously a risk that exists because that's how we identify the need for the product. And then just tell them to make sure that any other product selected by them is in fact appropriate to their needs and objectives. Right. With our record of advice, if it says record of advice, it actually means record of sales. So we only do a record of advice when a transaction or a contract in respect of a financial product was concluded. Now, it says providers must maintain a record of advice furnished to the client that reflects the basis on which the advice was given. It has to include a summary of the information that the advice was based on, which financial products were considered, which ones were actually recommended with reasons, and then we need to give the client a copy of this record of advice. Right, done with the advice part, done with the record of advice, onto the custody of financial products and funds. Now, this is super envy. They love asking about this in the exam. So, what they normally ask about in terms of financial products, they will only ask you what is supposed to happen when an FSP receives a client's financial product for safekeeping. The only rule there is they need to immediately issue a written receipt to the client. But when it comes to the custody of funds, things get a bit more intense. So, any FSP that receives custody of funds from clients must have a separate bank account for these funds. So, must have a separate bank account, but your client will not pay in the funds to the separate bank account. The client will pay in the funds to your normal transactional bank account of the FSP, the account used for all other things. Because we need to keep clients' money safe, we're not allowed to give out the separate bank account details. So, what will happen is clients will pay in the money to the transactional account of the FSP. The FSP will then have 1 business day. Let's just make that one a bit clearer. There we go. 1 business day to transfer the funds from the transactional account to the separate dedicated account. Now, in this account, there will be different charges. There will be deposit fees, there will be withdrawal fees, there will be interest earned, and there will be other account fees. Deposit fees we subtract from the client's balance. Withdrawal fees we subtract from the client's balance. Any interest earned belongs to the client. And any other banking charges the FSP has to pay for themselves. Just a little side note here, as soon as the FSP has received the client's funds for safekeeping, they also have to immediately issue a written receipt to the client. That's similar to what we just said about the products as well. Done with that part, so on to complaints. It says in the Code of Conduct that every FSP must have a complaints management framework. Every FSP will establish, maintain, and operate an adequate and effective complaints management framework for the resolution of complaints and the fair treatment of complainants. This complaints management framework must be proportionate to the nature, the scale, and complexity of the FSP's business and risk. It has to make sense for their type of business, their type of policies, type of service, and type of clients. And it has to allow for an investigation process when a complaint has been received. There must be no unreasonable barriers to complainants. We are not allowed to make it difficult for a complainant to complain. The requirements of our complaints management framework, so this just means that our complaints management framework must address the following points. There must be a part in our complaints management framework where we deal with the proper allocation of responsibilities, so who is responsible for what, the appropriate performance standards and remuneration and reward strategies for complaints management, procedures for the management and categorization of complaints. We need to clearly identify or define the escalation, decision making, monitoring, and oversight and review process within the framework. We'll talk about this one. Then the appropriate record keeping. So, in terms of record keeping, 5 years, every FSP must keep record of every complaint by having a complaints register. Every complaint received must be put on this register, and then once we have concluded the investigation and the complaint has been resolved, we need to put on this complaints register, we need to put the date on which the final communication was communicated to the client or sent to the client, and that's when our 5-year record keeping starts in terms of complaints. So we keep record of complaints for 5 years from the day that the complaint was resolved. Then we need to have a section that deals with the appropriate communication with our complainants, how we will engage with the ombud, and then we need to have a specific process regarding complaints about bad service to clients from representatives and our service suppliers. So, in terms of the allocation of responsibilities within the complaints management framework, it says that when we appoint someone to deal with complaints, we will call that person a complaints handler. Now, a complaints handler must be adequately trained, must have appropriate experience, knowledge, and skills in complaints handling, the fair treatment of customers, and the subject matter of the complaint. They must not be subjected to conflict of interest at all, and they need to have the mandate to make certain impartial decisions. If we don't allow a complaints handler to make certain type of decisions, it's going to delay the resolution process unnecessarily. Right. In terms of the categorization of complaints, it says that every FSP must categorize complaints The reason for that is mainly for reporting purposes, because we will report to the FSA on the complaints received, but it also gives the FSB an idea of what areas they need to improve on. If they constantly have the complaints category of advice as the main category of complaint, the main reason for complaints being received, then they know there's a problem area there and they need to look into it. Right, so it says that the FSP must categorize complaints in accordance with the following minimum categories. Complaints relating to the design of the product, so that's basically how the product works. Complaints relating to the information provided to the client, so the client is not happy with the factual information, might question it. Complaints relating to the advice, so the client feels that they were sold the incorrect policy. Complaints relating to a product's performance, this is when our client thinks that, but what you told me this product will do, it's not doing that, and I'm not happy about it. Complaints relating to the service provided to clients, complaints relating to complaints handling, complaints relating to insurance risk claims and non-payment of claims, and then other. These are our categories of complaints. They love asking in the exam about these categories. They would normally list a few and then want you to identify the one that should not be there. So which one of the following is not a category of complaint? Or they'll give you a bundle and they'll ask you which of the following are categories of complaints and you need to select them. So familiarize yourself with the different categories. In terms of the escalation and review process, this is something that sounds a lot more complicated in the Act and in your book and in your exam. It's not that complicated. Basically, what it just says is that we need to allow the client to escalate complaints when the client is not satisfied with the original resolution of the complaint. So, example, when a client submits a complaint, it gets still dealt with by the complaints handler. The complaints handler said to the client, okay, this is the solution of it. The client says, no, I'm not happy with that. The client will then escalate it to maybe a department manager. The department manager tells the client, okay, this is the solution of it. Client is not happy with it. They can now escalate it to the director of the company or whatever. This is the general idea behind the complaints escalation and review process. Now we need to allow our complainant, aka our client, to escalate complaints that are not resolved to their satisfaction. But we also need to allow the complaints handler to escalate a complaint. If this complaints handler receives a complaint from a client that is a bit intense, might accuse them of corruption or fraud or something bad, then they must also be allowed to escalate the complaint internally. Now, when we decide on this process and what it should look like, it says that the FSB must follow a balanced approach, which basically just means it needs to be fair to everyone involved. We need to allow for internal escalation of all complex or unusual complaints, and we need to allow our complainant to escalate complaints that are not resolved to their satisfaction. And someone must be put in charge of this process. It must be someone's responsibility. They say that it needs to be a senior person within the FSB or someone specifically appointed for this. In terms of communication with our complainant, we still have to make sure that we complain in plain language, not we complain, that we communicate in plain language, and that our entire complaints process is transparent and visible, easily accessible to our clients through channels that will be appropriate to them. We are never allowed to charge a complainant to complain. They must be able to complain for free. Charging a complainant to complain will be another unreasonable barrier. Right, so not allowed. In terms of our complaints process, every FSP will have their own complaints process, but it says that they need to resolve complaints within 6 weeks. If they cannot resolve the complaint within 6 weeks, the client is allowed to go to our FAIS Ombudsman directly and no longer has to wait for the FSB to resolve the problem. So when we disclose to the client our complaints process, we need to inform them of what type of information we require from them when they complain. Normally ID number, policy number, account number, things like that, and obviously details of what they're complaining about. Then we need to inform them on where, how, and to whom the complaint must be submitted, what the expected turnaround times are in relation to complaints, and any other relevant responsibilities of the complainant, what we need from them. After the FSP has received the complaint, they need to acknowledge the complaint And in that acknowledgement, they need to inform the complainant of the contact details of the person or the department that will be handling the complaint, any indicative and prescribed timelines for addressing the complaint, details of the internal complaints escalation and review process, details of the escalation of complaints to the Office of the Ombud, and details of the duties of the FSP and the rights of the complainant. It's important that the complainant is informed at all times on the progress of their complaint. If there's any delay in finalizing the complaint, that cause must be communicated to the complainant as well. And once a final decision has been made, that decision must be communicated to the complainant as well. Okay, that is where we will stop for this video. You will notice that advertising is not here. The reason for that is in RE5, advertising is not very popular in the exam. And when I say not very popular, I think in the last 10 years, I have had one question about advertising, and it's normally telephonic advertising. So I would recommend that you read through that part of the Code of Conduct in your book, maybe once or twice. Familiarize yourself with it, but I won't say go and study the advertising part intensively. Okay, then just a reminder, if you need to communicate with our office, please send all of your emails to info@rlptraining.co.za. My personal WhatsApp is constantly overflowing with messages, so this is a more effective way to get hold of me. All right, that's it. End of video.